back in order. Um, when we broke, I'd like to first of all welcome back the Guam Election Commission. Thank you very much for joining us again this afternoon. When we left off, we were going to start on Chapter 7. However, there is an amendment that needs to be made. We want to go back to Section 6107. Now recognize Senator Tom Atta.
Thank you, Mr. Chairman. I think maybe if I could just withdraw the amendment that I had made yesterday on 6107, which establishes a deadline for a candidate to decline. I would like to make an amendment which requires that individual who's being drafted to express to decline within 2 working days following the submission of nomination, petition papers, and other required documents by the sponsors. And so what this does is before the commission goes through the effort of certifying and all that, the individual should come in and express, yes, I will take it if I get certified or not. So the amendment I would make is on Section 6107, after the word commission on line 3.
Senator, do we first go to your initial to delete to withdraw your amendment?
Okay, so then
to reconsider.
To reconsider, yes. Then the motion.
Okay.
Yeah, the amendment that was made. Yes.
On that motion, no objections.
Okay.
So ordered.
And so then the amendment would be on line 3, after the word commission. That sentence then continues on to say within 2 working days following the submission of nomination, petition papers, and all other required documents to the commission by the sponsor or sponsors. And I have this in writing. I don't have it in writing, but I've got it here on my computer. He shall make known such declination in writing to the commission within 2 working days following the submission of nomination, petition papers, and all other required documents to the commission by the sponsor or sponsors.
Okay, on the amendment, any discussion? Okay, I'm sorry, Madam Speaker, you recognize.
Thank you very much. So if the individual or the sponsors themselves do not then submit anything within 2 working days, then does that mean then that the person that's an indication then that he is declining? Or you're just giving them 2 days?
Senator Atta, you want to yield to that question?
Sorry, can you repeat the question?
That if the candidate or the sponsors do not, within the 2 days, submit or decline rather that the candidacy, would the commission then automatically just remove them then as not then being eligible or a candidate?
Well, as I understand it yesterday from the discussion was that I guess because the submission of documents, there's not a certain deadline. I mean, there's a deadline when up to a certain date you can submit it, but I think it says here you can submit the paperwork up to about no earlier than 130 days before the primary and no later than 60 days before the primary election. So there's not one certain date, but I understood yesterday your discussion that as soon as you get the paperwork from the candidate, immediately you start going through the certification. You look up, I guess you verify the signatures and that he's got all the documents. And then as soon as you've done that, you notify the candidate that he's now officially a nominee, and then you move on to the next one. But then if you're just going to let him linger until... So I guess so I guess I guess in my mind, I'm thinking that that individual, once the papers are filed, he's got 2 days to come in and say, yes, I will run. And if he says no, then let's move on.
So, so the original language then basically is that whether the individual comes in or not, automatically they will be declared then a nominee or a candidate.
Well, the language reads in the amendments that he has to come in to make known such declination within 2 working days. Well, I mean, I guess if you can read that, if he doesn't come in to decline it, then do we assume that he'll take it?
See, that's what I was wondering. And if the sponsors are going to be the ones submitting this, do you require that you go to the candidates that, if we have these petitions on your behalf, but we would like to know is that are you going to accept, this nomination, and do you have to get it either verbally in writing from the candidate himself or herself that they accept, that nomination and now will officially be a candidate?
Well, then maybe we should go back and take a look then where it says, like on line 2, candidacy has been filed by political party, may decline or accept to be a candidate by making known such declination or acceptance in writing to the commission. So either way, he has to put in writing whether he will accept or not.
I'm going to have the acting chair.
Along those lines, you might consider too that anyone, in the event that a candidate's papers are filed through a sponsor or by a sponsor or the party, that it must be accompanied. You can cut it off of the pass, so to speak, and do it right then and there before they even come in. So to require that the candidate that they're drafting or the candidate that they're sponsoring did in fact know that, we're doing this and has accepted it and has approved our draft efforts, or so you can consider that, and require that.
Well, and now I'll tell you why I asked the question, because I remember it in one term. I was off island when I was going to school, and my petition, yes, was being circulated, but I wasn't on island to verbally or, submit in writing that I was then wanting to be a candidate, and that I had to receive a call and fax something, to let them know that, yes, I am then running for, that I'm wishing to be a candidate. So that's what I'm saying. Is that
And it worked out perfectly for you.
You're right, and and I did that because I was called to do that, and primarily because I made it at the skin of my teeth. Of course, I remember the election commission had to go to to the homes of these individuals who signed the petition to verify that they are who they are. In fact, because otherwise I wouldn't have been eligible. So those were 2 things that were pending then my eligibility. So I would think that if that even happened to me, unknowing that, I was off island, that anybody can put in your name and the individual may not even be willing to accept it. So I think there should be something to say that they are accepting to be a candidate if they are being drafted.
Yes.
And if they are being drafted, then that they would also can have the option to decline. So I like the amendment that Senator Ada is
So you
proposing.
can amend the amendment.
Yeah. So you can amend your amendment.
It could start in the event.
I mean, I think maybe an even more easy way to do this would just be to say this whole this phrase here and just say, prior to being certified as a candidate. If they never come in and accept it, then they're not going to be a candidate. I mean, if all of this, the certification not going to happen until they accept. If they don't ever accept it, then we'll never certify them. I think that would be an easier way to do it than giving them a timeline. You're trying to save the commission time of certifying a candidate. So I'm saying if they don't accept it, we'll never certify it, you know? I mean, that might be the easiest way to do it.
But I think their concern is the time in which they will do this. And what Speaker Wampat, if I understood you correctly, Madam Speaker, is that you need to have it done before it even goes to the commission, and that will be even more helpful to the commission itself and the staff certainly than trying to deal with people coming in with just, you know, haphazardly bringing in somebody's name. So if you, in the event that a candidate is being sponsored by 5 or more people or the party, that the papers must be accompanied with a letter of acceptance or with a letter of acceptance, period, because otherwise if he declines, then they won't bother to turn it in.
Yes, and I think that that's important because we talk about, you know, you not having the resources that you need, and that's a lot of work.
It is.
To you to have the
Maria.
staff go through, you know, every single signature to verify that, you know, they are who they are, they have the proper documents, and you do start to do all that, and then later on you find out that they've declined. So I think that that is important on the onset, is to know that they are accepting that nomination. So I know we need to take care of that first language that the senator had proffered before, maybe that he's suggesting as well that on line 2 is to add the word accept or decline.
Okay, thank you, Speaker Wampat. Senator Ada, would you like to revise your amendment?
Sure. So then the amendment should read then on line 2. It should read on line 2, candidacy has been filed either by a political party or by sponsors, may decline or accept to be a candidate by making known such declination or acceptance in writing to the commission within 2 working days following the submission of nomination petition papers and all other required documents. So the amendment to the amendment then would be to add the word may decline or accept, and then on line 3 where it says declination or acceptance.
Thank you, Senator Ada.
And I'll go ahead and I'll submit that. Do we have a clerk that so we can submit to print?
On Senator Ada's amendment? No objections? Amendment carries. Are there any other discussions on 6107, Senator Yamashita? None, okay. If not, we're going to move on now to Chapter 7, ballots. And we're in Section 7101. I recognize Senator Yamashita.
Mr. Chair, this is not on the section that you just cited, but it is on a section that we spent a great amount of time on yesterday. And I'm sure we all read our newsletter this morning with the National Conference of State Legislators and how the U.S. Department of Justice has just rejected Texas's attempt for their voter ID, which requires them to use a photo. And I'm just wondering, does that impact what we discussed yesterday in subsection 3101?
Okay, I guess that's a question for the commission. Maria? If you
Well, it's a different circumstance because the title what we talked about yesterday was for registering to vote. The Texas lawsuit or being sued for polling place when you go to vote. So it's a different circumstance. It may affect us, yeah. I mean, really, we got to get as many people as we can to vote, and it's up to the body to figure out how we're going to do it.
So there is another section in here that talks about what you have to show to actually vote.
Yes.
Okay, I'll wait till then. Thank you, Madam Speaker. Second paragraph on page 1, we're wondering if that paragraph is actually needed in that it proclaims that there were all these problems that we didn't actually specify. So we were just raising that to see if that paragraph is needed there. Second paragraph.
Okay. Is that an amendment, Senator?
An amendment to delete the second paragraph.
Okay, we went back to page 1, the legislative findings and intent.
Page 1, yes.
Yes, and the amendment is to delete the second paragraph. Am I correct, Senator?
Yes, sir.
In its entirety.
The second paragraph,
Yes.
yes. I think the first paragraph defines how the commission has made the attempt to consolidate,
Mhm.
make more effective and efficient.
Mm.
But I'm not sure that we want to say that we had all of these problems. I'm not sure that's our place to say that.
Okay. On the amendment, any discussion? Senator Palacios and then the Vice Speaker.
Thank you, Mr. Chairman. Mr. Chairman, I think that it says here unresolved the problems encountered in the 2010 election. I mean, and my understanding is there are some errors, I think, made or misjudgment and other things. For example, some of these volunteers did not show. We did have problems in the last election. We did. Has nothing to do much with, I guess, impropriety and so forth, but rather just the administration of it. The administration, for example, of the early voting, so finally that was suspended at this point. But to just, you know, I guess this is a very narrow presentation here, resolve the problems encountered in 2010. So there has to be a need of a mention of what we're trying to do. And I'm not objecting to the deletion of this, but we're just not updating this because we want to update it. But what prompted the updating of these rules and regulations actually all of these complaints and so forth, whether they're legitimate or not, but there were some questions, you know, as to the administration of the last election. That's just my comment, Mr. Chairman.
Okay. Thank you, Senator. Thank you, Senator. And yes, there was a bunch of things that went wrong with the elections that the Commission convened a subcommittee, and there's actual findings that the Commission has and has forwarded to the Attorney General and to the U.S. Attorney's Office. Understand it? Yes, that's right. Vice Speaker? Yes.
Mr. Chairman, unless I'm mistaken, that was the reason that early in this legislature we passed those two bills to direct the Election Commission to address some issues that had resulted in not just 2010, but in prior elections. And I agree with the last speaker, but I'll go a little further, and I will say I object.
Thank you. Senator Respicio?
Thank you very much, Mr. Chairman. Mr. Chairman, along those lines, at the public hearing, I requested for a copy of what those findings were. And at the public hearing which you conducted, the Guam Election Commission Board was not prepared to discuss those findings because the basis of that public hearing, as you set out in the ground rules, was to discuss their response to the law that was passed that required them to do this very thing that's found in Bill 413. Maybe we can, I don't know if we're going to dispose of this motion. If we are, then I object as well. But I'm thinking that if we're going to say that this is to resolve the problems encountered in the 2010 election, a resolution to these problems would require a runoff or a re-election, right? So instead, Mr. Chairman, maybe we can list what those findings are by the Election Commission themselves, so none of us are perceived to be biased toward one camp over the other. And I expect the same from all members of the Guam Election Commission when it comes to the conduct of these elections. So my suggestion is that we get a list of what that report is, which you just referenced, and we highlight all those findings found by the Guam Election Commission and show that, as Senator Palacio said, this is the legislature's response to how the previous election was conducted. So I won't object to that amendment, and maybe we can go back to Chapter 7, but in the meantime, ask for a copy of those findings, and I'll be happy to offer that as a floor amendment later on in this discussion. But for purposes of this amendment, I object.
Thank you, Senator Respicio. Senator Dueñas first.
Yeah, Mr. Chair, I got to say that notwithstanding the objections, I'm inclined to support the motion for one purpose and one main reason, is that currently, at least what some of the accusations have arisen to is a lawsuit. And we're here now addressing what I think in the title as introduced, perhaps long-standing issues, and we're going section by section, but there's no resolution at the court. So we couldn't even say right now that we're fixing perceived flaws. And so, I mean, as the chair as well and as the author of this legislation, I would ask, you know, and because this is describing our intent, I would be cautious in saying that that's what we're doing here, given the fact that there's pending litigation. I think that the true intent of this body at this point in time is to revisit the process, and that's why even when the Election Commission set out, and the good work that you did, Mr. Chair, of all the hearings leading up to this process, and even at the outset by one of the members in the letter that she penned, was the fact that these were the findings. And those findings had nothing to do with litigation. They had to do with discrepancies over the years that we found. And that's in the conduct. That's not in anybody's malfeasance or any intention to try to skew the election one way or the other. Just simple growth process of doing this every couple of years. So I just find, and as I discussed with my colleagues and others, that maybe there's some wordsmithing to be done, but I think the reason why it came up, and in our discussions, the reason why I support it is because truly we're preempting ourselves and saying that we're solving something that is currently being litigated. So I support the motion at this time. Thank you, Mr. Chair.
Thank you, Senator Dueñas. Senator Mana?
I too am also inclined to support this amendment. You know, this measure, I believe, was introduced. This bill was introduced as a means to update the antiquated laws that deal with our election, and this one provision here seems to me like it's singling out just one single election. I believe there's always going to be problems and glitches that arise in the election, and we can't just focus on one single election with this measure. Thank you, Mr. Chair.
Thank you, Senator. The section that's being proposed to be deleted indicates that this resolves the problems encountered in the 2010 election as well as in other prior elections. So other elections are included there. Any other discussion on the amendment? Senator, would you like to close?
I do appreciate the conversation. I just, I appreciate the previous speaker in that what I'm really now concerned about is what exactly those problems are. You know, some folks paid a lot closer attention than others. Some folks are are veterans at elections. And so for some of us, it's what exactly were those problems. So I appreciate the attempt to get that list. Thank you.
Thank you, Senator. On the amendment to...
Point of order, was she withdrawing her amendment?
No.
Okay.
Thank you. On the amendment to delete paragraph 2 of the intent and findings, All those in favor? Motion fails. Okay, we're now on Chapter 7, ballots, Section 7101. Any discussion on 7101? 7102? 7103? Senator Spishu?
Can we go back to 7102, Mr. Chairman? And my question is, have there ever been an instance where they had found imitation or unauthorized ballots or printing of additional ballots which have not been accounted for? Because that might be seen as imitation ballots also if it's not properly accounted for by the Guam Election Commission. Was there...
I am not aware of any, but all of us have been sitting on the commission for just a few years, so I'd like to defer that to Mr. Mesa, who has been on the commission longer than any of us. So,
I'm sorry, Senator, what was the question?
Well, my question is, if has there ever been an occurrence where you have found imitation or unauthorized ballots, or in the case where there was printing of additional ballots that may not necessarily been accounted for by the Guam Election Commission Board?
No.
Okay, and this section will continue to prevent those occurrences. Okay, thank you.
Thank you. Senator Palacios?
Thank you, Mr. Chairman. My reading of 7102, Mr. Chairman, is, an example is, for example, the publication of a sample ballot. I know there was a time when, this is copied to the machine and so as to, educate friends as to, who to vote and so forth. Now, when we say no person shall make or use, does it refer to actually using it to cast a vote or using it to demonstrate? For example, crossing means you check here and you check there. You need, I guess, a copy of the ballot, which you will cut out from the newspaper, and to show that if you vote on this line, you stay on this line. Otherwise, if you cross over, by the use of that simple ballot, rather example of a ballot for that instance, would that amount then to a violation of 7102? That's what I ask. I just want to be clear, because I don't think that 7102 applies to that kind of event. I think it applies to when you're actually marking the ballot to throw it in to be counted as an official casting. But we just want to clarify 7102.
Senator, Mr. Chair, if I may? Senator, if you notice, the one we publish in the newspaper says unofficial sample ballot, okay? So it's designated. Actually, the official ballot, the ones that we do have, are coded. And those are not, that code is not printed on the sample ballot that's distributed to all the candidates, okay? So you can use that that should not be considered an imitation.
Thank you then.
also, I just want to call your attention to the paper stock. It weighs, the stock of the paper is a certain weight, and at the end of the day when they close the polls, they have to account for every ballot. So an audit is done, and every single one is counted, and if anybody tried to sneak one in there, it would be caught there, and certainly it would not go through the tabulator. It would be automatically rejected. But at the closing of the polls, they account for every ballot that was given to that precinct that morning.
Vice Speaker, you recognize?
Mr. Chairman, how many of the members up there were in the last commission that oversaw the investigation of the 2010 election? If memory serves me correctly, and I know I'm senior now, but if memory serves me right, wasn't there an issue of stock being left at the printer? That everything wasn't picked up at the printer of the ballots? I thought there was either allegation or finding that there were problems with not accounting, of them not taking everything from the printer and those not being accounted for.
I recognize Commissioner Trillo.
There was listed in a subcommittee report a problem with the actual number of ballots that were printed and cast. It's not clear at this point how many ballots were printed and cast.
But I asked that same question, but Director Mesa said that he wasn't aware.
No, I
I
believe
asked two questions.
your question,
It was
Senator.
imitation ballots.
Right.
But a
Was a ballot ever used, imitation ballot ever used in an election? My answer to that was no.
Yeah, then a follow-up question was there an overprinting of ballots that wasn't accounted for?
I didn't answer that question.
Okay. I'm glad the Vice Speaker had a follow-up, so now we can address that question. Thank you, Mr. Chairman.
But if I will answer the Vice Speaker's question. In fact, yes, what was left what we found was what was left at the printing press was the plate, the printing plate, okay, and some ballots that were spoiled, but they couldn't be used.
Thank you. Any other discussion on 7102? Moving on, 7103. Senator Respicio.
Thank you, Mr. Chairman. 7103 is a new section, correct?
No.
You've always had verified voter paper ballots in your rules and regs?
I think this is a legislation that you proffered last year, right?
Yeah, this is a legislation that we passed, Public Law 68-31.
Yes.
And I say that, Mr. Chairman, because Senator Ruth, when you opened up yesterday, you said that a lot of these provisions are still a rewrite or a rework because over the years the statute has been amended. But I wanted to create some discussion on 7103 and recognize the Guam Election Commission Board and its staff for putting into this updated rules and regs a new Public Law 68-31. And this verified, voter verified paper ballot, I just want to reiterate that it's an electronic voting machine, and then the ballot is printed, and the ballot is put into the other ballot. So if you're a voter, whether or not you use the machine or use your own pencil to mark your candidates to vote for, that ballot is counted at one time by the tabulation machine. So unlike the current electronic voting machines, there was no paper trail. And that's why we moved to suspend the use of those machines, which I took deep criticisms for publicly, saying that I didn't want to recognize what the technology is. And so that kind of technology, you couldn't verify whether or not the votes were going to the proper candidates. But this will.
If I may, and this is pretty good, but you might want to look at it just one step further. If I'm voting using the voting machine, it's already tabulated. And then I take the verified paper, the so-called paper trail ballot, and put it in. So you need to look at that in the statute or in the proposal to make sure that that vote is not counted twice. That nobody down the line or later on is going to say, well, we have to count these in the box because something happened to the machine. So the chances, are greater for the possibility of some votes being counted twice. So you might want to look at that.
That's a fair statement, Mr. Chairman. Doesn't this, this amendment doesn't say you count the votes twice.
No, it doesn't.
Yeah,
And then
it
that's
says it says if you're to use the electronic voting machines, you are to use a voter verified paper ballot.
if we use the electronic voting machines, this, I
But
believe...
but if you use a voter verified paper ballot, those votes are not tabulated by the machine. Your ballot is printed, and then there's the tabulator tabulates all the votes, whether it's cast from this machine or whether it's cast from. Basically, it's just like you're going to a computer, and then you print your document, and then that ballot can be fed into the machine with the other ballots that were voted by hand.
Well, we could be setting up ourselves for some human errors to occur where, you know, they count the verified paper ballots anyway after they've already been counted by the machine automatically connected to the tabulator. Because it doesn't say how you want to, how the legislature wants to
So, Mr. Chairman,
view the paper ballots.
Yeah, so I guess on page 46, I'll offer that as a new item G, that the votes shall be counted only once, whether the voter whether the voter used the electronic voting machine or voted by hand, that those votes shall only be counted once. And I'll work with the legal counsel, and then we can come back and adopt that as an amendment if the body so chooses.
Because I see the verified paper ballots as being useful in the event later on that precinct count is questionable, and then you have to, do something and count something, and you have that trail that you refer to.
So if we can put a star or asterisk in this section, and then we'll come back to it, and I'll offer an amendment.
So that would be as G, you said?
Yeah, and I'll offer that formally to the body when we come.
Okay, thank you. We have Senator, sorry.
Can I, just for the senator's information, we met with a number of election people from who are in the business of election machines, and according to them, the wave is moving away from the electronic and going to the paper because there's a lot of problems with the electronic.
Thank you. Senator Toniata.
Thank you, Mr. Chair. Mr. Chair, I'd like to offer an amendment on 7103A that the electronic voting machines used in Guam elections are warranted to be accurate by the manufacturer. And after the word manufacturer, I'd just like to place in prior to each election wherein the electronic voting machines are to be used. And that's just to ensure that the machines are always accurate prior to the election, and not just from the manufacturer whenever we purchased it, that these machines are accurate. So.
Okay, thank you. On the amendment? Same one, okay. No objections to the amendments? To the amendment, motion carries. Same one, okay. We're still on 7104. I'm sorry, that was 7103. We're now on 7104. 7105. 7106. 7107. 7108. 7109. 7110. Speaker Ben, you recognize?
If I could just go back to 7108, we never kind of resolved the issue of that new political party, and they were saying that perhaps they become placed in the write-in section and so forth. Has any additional thought been given to that as we look at the writing for on the write-in section?
This subsection is strictly just that, for the write-in section. In relation to the new political party, I think that once you decide how you're going to deal with that in statute, you're going to have to come back to this. because under a new political party, once they make it on the ballot and they've fulfilled all the requirements of law, that they would also have their own write-in lines. And so you're talking 3 columns on the ballot. That's correct.
Thank you. 7111, 7112, 7113, 7114, 7115. Speaker Ben, you recognize?
The question I have is the name, you know, and I'll use myself as an example. And I think I thought I wasn't able to do this. Was, you know, I have my name all in lowercase, and I think the commission wouldn't put my name in lowercase. Is there a rule that says, you know, when you put your name that it has to be printed in a certain way, they all have to be the same, other than the nickname section?
I'm not aware, unless Mr. Mesa or Mr. Taitano remembers.
You know, there's the official side of the ballot, I guess, so the legal side where your legal name is or whatever, and then you have your nicknames. Well, on the legal side of my name, for example, like myself, everything's lowercase. Vicente C. Pangilinan is lowercase. And I think the Election Commission told me that they wanted to put it in, you know, capital V instead of lowercase v, and so forth.
Perhaps it's just to cut down on having to proofread every little instruction that a candidate might have.
Okay.
Because I write in lowercase too, including my signature.
Right.
But otherwise it doesn't, you know.
So there shouldn't be any prohibition against that, right?
I don't believe. It's really what the candidate wants as long as it's legal.
It's correct.
Right.
Okay. All right. Thank you.
Thank you. 7116. We're now in Chapter 8,
It's more work.
Election Campaign and Campaign. Sorry, yes, Senator Guthertz.
And again, I want to go back to our experience in the last election. I thought something very peculiar happened, where ballot boxes supposedly secured at the Guam Election Commission office at the GCIC building had a private security guard from a private security company outside the door of that ballot area. Now, I don't know if this was authorized by the Election Commission Board or wasn't, but I think it was inappropriate. And if there was a need for security, then the Guam Police Department should have provided the security for obvious reasons. So I'd like to hear about that. Can someone explain to me about that? Or is that under review in the courts at this time? Did someone give permission for the private guard to be there?
I guess I'll respond to that, Senator. I think there was one instance, and I think this was immediately after the election. One of the teams had one of their security guards there. It was not authorized by the commission. I think it was replaced by a police officer.
How long did it take to do that? It took quite a while because that was, my recollection, it went on for over a day.
No, it was less than a day.
Like how long? How long is less?
My understanding of my recollection, about 7 hours. But the individual had no access whatsoever to the room.
That may be true, but the appearance looked very poor. And question came up, why is the Election Commission allowing this?
The commission did not allow it.
Then you should have had the person removed.
Well, and that's why the police officer was assigned there.
Now, what protections do we have now that that won't happen again, and that the commission will act much quicker to make sure it doesn't happen at all?
You can include in the bill a sentence somewhere from the time that the ballots are brought back to the commission that a police officer or 2 or 3 or 4 be stationed until everything is certified. Because in order for us to get police escorts the morning of the election to accompany the ballots and the people over there, the executive director has to make that request way in advance, and they have to figure out how much it's going to cost for police escorts and whatnot. So it's really just a matter of requiring it in statute.
Okay.
That police presence is there, and the police department can factor that in its own budget to pay for that.
Well, first of all, let me say, having been with the police department, I'm sure they would be willing to have someone there immediately upon the relocation of the ballots from the precincts, because they're already assisting you anyway in that process. And I think in order to maintain public trust in this whole thing, that we need to include a provision here under section 7116. I want to ask legal counsel to please help with this, to add a provision that there shall be no private security guards representing any candidate team allowed to be within 1,000 feet of any room, any location, or any appearance thereto where ballots are housed. Absolutely not. And I don't care what team's represented. It's not proper. I'd rather have the Boy Scouts or the ROTC cadets there than any hiring of any private security company to do that, especially under the nose of the Election Commission. That really created questions and created a lot of bad feelings. And whatever the intent was, it may have been good, but it didn't look right. And it weakened the Election Commission board and your work. So in order that it does not occur again, I'm requesting, Mr. Chairman, that there be a provision here, as I stated. Maybe the language can be a little different, but not within 1,000 feet of any location where ballot boxes are held.
Thank you, Senator. So on that amendment, having a legal counsel draft that, but on the
Point of information, Mr. Chair?
Yes.
Yeah, I think that, well, at least in the current location, if that building uses security, then the building would have to not use their security for the building. 1,000 feet is quite a distance.
Yeah, but I think she's talking about any candidate owns personal security. So it doesn't cover the building's own security.
Okay, so the building would still be, okay.
Yes.
Just I need that clarification.
Yes.
Thanks.
Thank you. Okay. On that amendment,
well,
yes,
I can
Senator
understand
Blas.
the concern. I'm just worried about the wording and how it's going to be worded and stuff. And I would appreciate before we take any action on that I see the wording that I'm not adverse to coming back to this once the language has been.
Okay, so
Okay.
we'll come back to it. We'll put
Please.
a mark on it, and yes, with the language.
If I may, you might look at the use of peace officers also in.
That's
in
where my concern is at.
Yeah.
Okay,
No,
so we'll
but
wait
as
till the
opposed to
amendment is
police.
drafted, and then we can entertain it. We're moving on. Yes. Yes.
You know, if ballot security is such an issue, I mean, our biggest problem is that the Election Commission's problem is that we don't have funding. But within 1,000 feet of the Election Commission, there's a bank with a vault. Maybe we can get funding to store the ballots in the vault until, whatever it is. But security shouldn't be an issue when there's vaults all around us. There's 5 banks in Agana. If you're worried about storage of ballots, have them stored in the bank and make an agreement with the bank to put the ballots in there every day. Or, something.
I think that's great. My problem is when you allow private candidates
Yeah.
to directly hire security and put them in front of the ballots.
Senator
It looks
Gutierrez,
funny.
I
It looks
understand.
really funny.
I understand.
Gosh, it's like saying we can't.
That wasn't the
protect
Election
it, so-
Commission that did that.
Yeah. I know, but you should have chased
And
them away when
if
it
anything,
happened.
you would have to admonish the candidate that did that.
Yeah, but
And you
I
cannot
also
admonish the
say
election commission
the board
for
has
that.
responsibility to say, go away. That's within your powers.
Yes.
Thank you, Senator. And so we'll get back to that when the amendment is before us. We're now in Chapter 8, election. I'm sorry.
Yeah, I think also on 7116, we use the term peace officer. Are we trying to be more flexible, or are we just trying to, do we really just mean police? I mean, have we ever used peace officers to accompany the ballots to satisfy this section of the law? Or do we just mean police?
We want police.
I have, along those lines, mayors and vice mayors are peace officers.
Yeah, that's what I mean. That's why I'm asking.
And if in the course of an election, especially like this year, are we saying that, you know,
Okay, so do we have an amendment to? Okay.
Well,
Please state the amendment, Senator, Speaker.
Thank you very much. In 7116, where we reference the ballots and the precinct board officials shall be accompanied by a peace officer, I want to change that to police officer. And it would be the same as in 2 and 3.
Okay, on the amendment to replace the word peace officer to police officer, as it is.
In 2, now in 3, that I'm kind of rereading 3. So in 2, first in 2,
Okay.
that's my first amendment.
On number 2 of 7116, no objections. Motion carries.
In 3, I kind of reread this after that change, and I'm kind of a little confused because we're saying now that the government of Guam buses be utilized to transport the ballot boxes, the precinct board members, and the peace officers to the election return center. Now, I thought the police officers under current practice kind of escort the bus, and they're not inside the bus. Are they on the bus? No, right? They kind of escort the bus with their own car? So are we now saying that we want them in the bus?
well, that was peace officers, and like Senator
Well,
Blas
then,
said,
yeah,
that they
but-
could mean the mayors.
No, but I'm saying that I think you meant both. So, I mean, when you said peace officers and you mean police there, I'm sure you mean police officers as well in 3. So, just curious of the change there. And do we want that the police officer who's accompanying the precinct officials and the ballots to be inside the bus and not escorting the bus? Because I am correct if I recall that they escort the bus. They don't really ride the bus.
You're correct, Senator. There are some cases where the officer doesn't have a vehicle, so they would ride the bus. Okay, and another officer probably escorts them. Yeah.
So do we want that? Is it now?
Is it mandatory?
No. Well, it would be here, right?
Mhm.
I mean, is that the recommendation of the election commission that police officer stay in the bus?
In the bus.
Okay, I agree. I think that'll be greater comfort to everyone that, you know, the ballots are safe and they're not being tampered with while being transported. So I would also change that then to police officers and be very clear that the current practice of having the bus escorted is no longer sufficient, that the new practice and regulation will be that it is the police officer accompanies it inside the bus. Okay. And hope we don't privatize, because then we'll have to come back and change government of Guam bus. Okay.
Thank you, Senator Pangilinan. On the amendment, Senator Palacios.
Thank you, Mr. Chairman. Just a comment on that issue. There was a time when actually the intent is for that officer to remain with the box, from picking it up at the election headquarters over to the voting place and to the central, and to actually ride on the bus and remain with the box. That was in the olden days, and I think there was, it's clear there that there has to always be a police present or that security right there constantly with the box. So I think writing on the box with the box, I think that would be the most complete process in securing the box. So I support, of course, the amendment from Barrigada.
Thank you, Senator. Vice Speaker, did you have Okay. On the amendment, no objections, motion carries. On 7-1, we're still on 7-116, Vice Speaker?
I may be lost, but where's the definition of precinct leader and the change from precinct leader to inspector? Or inspector to precinct leader? In this series, in this sequence of statutes, I note you amended
Where are we?
inspector to be precinct leader. Is that correct? And I'm wondering where the definition is.
I'm sorry, where is he?
I don't find it in the definition section. Unless I'm missing it. Does anybody?
There is no definition in the title for precinct leader at this time.
That doesn't give me any definition of what precinct leader is.
4104, sir, I think is where yeah, there are 5 members consisting of 1 precinct leader and 4 precinct clerks. The occurrence of any 3 members shall be necessary for any ruling on the precinct.
I understand. I'm just saying in the definition section at the very beginning of the statute, there is no definition of what a precinct leader is.
Yeah.
You're right, Vice
You're
Speaker,
right,
there is
sir.
no definition.
The other thing is the amendment that was proposed or has been discussed by a number of people about security. And we may have problems with 7112 because for receipt of ballots, it goes, the precinct leaders shall sign the receipt upon receiving the packages, which shall be forthwith be returned and filed. The commission may employ such persons as may be necessary to ensure the security and safety and expeditious delivery of the ballots to the precinct boards and fix a reasonable compensation for their services to be paid as other election expenses are paid. So I know that people didn't want to use private security. I'm just wondering how we're going to address this, because again, though memory may be failing me, I think in the last election we had problems with an employee of the commission or a board member driving around with a briefcase with ballots without any other person with them, and I see some board members rolling their eyes, which I'm famous for. So I'm just, so I'm just saying, where's the security to make sure? Because in 7-111 it says it should be in a package and it should be delivered and everybody should be signed off that precinct 7A is supposed to get X number of ballots, and that's it. But if memory serves me right and my recollection is correct that somebody was driving around with additional ballots, how is that to be delivered and what receipt?
You guys looking for me to answer that? Okay. Your memory is not not going away. There was, it wasn't, it was absentee ballots that were received from what I understand, and he was delivering them to the various precincts. And somehow, some of in the original delivery, some of them were delivered to the wrong precinct, so he was correcting that. So they're two different cases.
And that's what we're trying to figure out. How do we write this so that there is a fail-safe way of making sure that, as one of the commissioners said, every ballot is accounted for, it's got a code on it, and the weight's not going to allow it to go to the machine. But the thing is if you're not having a master count and it takes 3 people to leave with 10 ballots to go to precinct 27, you know, that no one should be allowed to have ballots by and for themselves. There's got to be something that says before any ballot, 5 ballots have been given to Commissioner X to take out to precinct 17, 3 members have to sign that Commissioner X was given 5 ballots, and precinct 17 should sign off that it received 5 ballots, not 50.
You know, Vice Speaker, I believe that the mechanisms are in place. Now, were there errors? Were things done wrong in the last election? Yes, they were. If they were followed to the teeth as they should have been, then we would not have had any problems. Somehow there was a breakdown, and you know the commission recognizes that. That's why a subcommittee was formed to review all these, even complaints that were not raised. The commission had certain concerns, and I believe that going forward, we have the right personnel in place to ensure that does not happen again.
Thank you. Because in one of my earlier questions about the ballots that were left at the printer, and I'm just wondering, was there certification that these ballots were destroyed, and which 2 or 3 commissioners signed off that these ballots were destroyed, or somehow what happened to them?
Well,
there has to be an SOP that says spoiled ballots, 3 of you have to sign off or whatever, or 4 signing off that 22 ballots were taken from the printer, that something was wrong with the printing, we're destroying these 22. But to just leave it and have no paper trail of what happened to these ballots leaves the outcome questionable.
And again, you're correct. And as I stated earlier, if the SOPs that are in place were followed, this should never happen. Unfortunately, it did, and I believe that the Commission is taking the appropriate steps to ensure that that does not happen in the future.
Thank you, Vice Speaker. We're now on Chapter 8, Election Campaign and Campaign Offenses. We're in Article 1, Section 8101, Section 8102, 8103. Senator Respicio, you recognize?
I noticed that the severability clause is here. Is this necessary? Maybe if you put this at the very end of this. So I'm proposing to delete this, or move this to the very end.
You're right.
Yeah.
It doesn't need to be there, but
It
we
doesn't
were
belong
not
in
in the
this area.
position to delete that ourselves.
But you were recommending that the severability clause be placed right here.
I'm not sure whether we just didn't know where to put it, but there, you know, it could be in the end.
So I move, Mr. Chairman,
Yeah.
to move this in the end and authorize the league council to number it accordingly.
Okay. Any objections? No objections? Motion carries. Section 8104, 8105, Senator Toniata.
Thank you, Mr. Chair. This is for the commission members. What's going to happen on the complaints there? We got on line line 4, in the event the person is convicted of a violation subsequent to the election in question and was elected to office for which he or she was a candidate, the Attorney General shall take necessary civil action to effect the candidate's disqualification from office. What would happen from there? Does number 16 move up? Do we hold a special election?
You know, Senator, I'm not sure, but I think if the individual is sworn in, I think that that rests with this body to determine the eligibility, right? Right.
I think Commissioner Mace is correct. Once the person is sworn in, it's ours. If you can catch it before they get sworn in, then
It's
there
in
may
your
be
court.
some move. But in 2 legislatures ago, we had that situation where there was question as to whether or not that person was qualified because of a alleged prior felony or prior felony. And so it became a thing where it had been sworn in, we had to do the removal from here, and it was vacant.
Did that answer your question, Senator?
Thank you, Mr. Chair.
Thank you. Any other discussion? 8105. We're now in Article 2, Dishonesty and Fraud in Elections, Section 8201, 8202, 8203, 8204. Speaker Pangilinan.
To 8201. We're saying that, if I read this correctly, to sign an election paper, any person who accepts any bribe or promise of any gain of any kind for signing the same, whether the bribe or promise of gain be offered or accepted before or after, shall be guilty of a felony of the 3rd degree. Does this mean that we will now not allow and ban organizations, individuals, associations, groups that, if you recall, at times would pay people to circulate petitions and then pay like 50 cents a signature? If you recall, I think we did that with some of the gambling initiatives, some of the other initiatives in which individuals were paid based on the number of signatures they got in on a petition. So does this cover something like that in your reading of it? Is this the intention? Because this seems to be, I don't know if this is added language because it's in a new section or old language. So is that what this, so how then, if I read this correctly, how then were those petitions accepted that, were paid 50 cents a signature?
You know, Senator, from what I recall, I don't believe that a complaint was ever filed on that.
Yeah.
Now, if a complaint was filed, we've heard stories that people were being paid, but no one officially filed a complaint with the commission. I believe if one was filed, then we would have looked into it.
Okay, all right.
Unless we, are given the
You couldn't act on your own motion? On your own volition?
The best that we can do is direct our executive director to forward it to the Attorney General's office. And, as in the last election, there was a complaint about bribery or improper campaign spending that we're looking into forwarding to the Attorney General as soon as our legal counsel accepts it. So there are issues, but this provision is put in there to ensure that no one is paid for their vote, and that you earn the vote the way that senators and governors and everyone does.
Mr. Chairman?
Thank you. Yes, Senator Speaker.
In that scenario that the previous speaker explained, if the campaign worker is given 50 cents for each signature that he or she collects, is that considered a bribe versus the person that signs that petition receives 50 cents? I think in the first case it's not a bribe because you're paying a campaign worker, but in the second case it is a bribe because you're paying your potential voter. So if I'm not mistaken, I think what the previous speaker described was that the campaign worker was being paid 50 cents or whatever it was for the number of signatures they were able to get. In that case, that activity will still be permitted under 8201?
You cannot, I don't think it's possible to preclude a campaign from paying staff for doing a service for the campaign. But the campaign itself cannot expend money to an individual to support them or whatever it is. You know, I can't go out and give Senator Pangilinan 50 cents to sign my petition. That's illegal. But if I'm paid 50 cents to get his signature, that's not illegal because I'm being paid by my campaign.
Okay.
Well,
Senator
that's
Barnes?
a fine line, Senator.
The question was, what if you sign my petition, hypothetical, and I give you a pen or a T-shirt or a flashlight or
I think that that's a different circumstance because I'm giving you something. I'm not giving you something that will financially help you. When you're talking about bribery, it has to be something that's going to financially help you, a job, money. You know, if I give you a pen, I'm asking you to use my pen so that people see Senator Tina Muñoz Barnes. You're in my heart.
Thank you. Okay. We're on 8202, 8203, 8204, 8205, 8206, 8207, 8208, 8209, 8210, 8211, 8212, 8213, 8214, 8215, Section 8216, 8217, 8218, Section 8219. We're now in Article 3, ballot-related offenses. 8301, 8302, 8303, 8304. Yes, Senator Barnes.
Is there a way of reconciling ballots printed versus ballots disseminated versus ballots turned in? And I know that was one of the concerns based on a precinct getting 100 or 300 ballots, but when it came back, there was 320 ballots coming back. I mean, is there a check and balance that is incorporated into this? What section does that show in? You got the adding to the ballot in the box, adding.
There is a section. It's not under this particular one because all of this involves criminal activity. I mean, the penalties and so forth. But I believe maybe in Chapter 9 there probably is something because it requires a full accounting.
Thank you, Senators. 8305, 8306, 8307, 8308. We're now in Article 4, Election Officers, Sections 8401, 8402, 8403, 8404, 8405, 8406, 8407, Section 8408. We're now in Article 5, Other Provisions, Sections 8501, 8502, 8503, 8504, 8505, Section 8506. We're now in Chapter 9, Conduct of Elections. Okay. There's a request to take a short recess break for a bathroom break. Any objections? You know, so we're on break for a few minutes. The Committee of the Whole is now back on. We're now on Chapter 9. Any discussion on Section 9101?
Mr. Chairman,
9101. Yes,
sorry,
Mr.
Senator
Mabini.
Mabini brought this to our attention here on 8504 regarding publications reflecting on character of candidate. It says that a person is guilty of a misdemeanor if they don't comply with this requirement. But further back in this document, the Election Commission incorporated a law that we also passed regarding campaign advertising and the penalties for third-party ads if they're not properly there's no proper disclaimer. I have my staff looking to see if I think in the law that we passed, it sets up a felony, but in the Commission's recommendation, it just says I'm jumping all the way to page 188 because it's kind of dovetails with page 76, but in page 188 it says shall be subject to a civil penalty of no more than $5,000 per each separate produced message. Do you recall if I thought we set the penalty as a felony. Do you recall if that penalty was dumbed down in this rewrite? Okay. Is it still showing that it...
We probably will eventually get into it, and it's good that you caught that, but it just brings up
but we never...
more attention for us to, look out for it.
Okay, it may have been the version. Your version may have reflected the version that we passed in the legislature because it's showing civil penalty of not more than $5,000 per each separate produced message. But so I'm wondering then if on page 66 we should match that misdemeanor.
What subsection? Because I don't have.
It's
my 66 is not.
It's 8504.
Okay.
Regarding publications reflecting on the character of candidate. It says every person is guilty of a misdemeanor who intentionally writes, prints, posts, or distributes or causes to be written. And it goes on and it says that these have to be, you have the name of the chairman and secretary, the two names of officers of political party or any other organization issuing it, or the name and residence with the street and number thereof if any of the person responsible thereof. But if someone violates this section, they're guilty of a misdemeanor. Now, we had passed an earlier law in the legislature, which is reflected all the way on page 188, and this deals with third-party black ads. And the scenario for a third-party black ad is if someone was going to do a black ad against me, they'd actually have to show me that ad, whether it's print or something to be posted on YouTube or Facebook or wherever, or even to be run on the media. They'd have to show me the ad, and they'd have to disclose who the treasurer is, and they'd have to say Roy Respicio does not approve of this message. Or likewise, if we're running ads, we have to say I'm Roy Respicio and I approve of this message.
So what?
So that third-party black ad, Mr. Chairman, is similar to the provisions of 8504 in that if somebody runs any advertising against any candidate for any office, incumbent or not, that they have to disclose the name of the chairman and secretary or the names of two officers of the political party or any other organization issuing it, or the name and residence, of their street number. So the idea behind these two provisions is that we're looking for full disclosure. And if certainly it's within an individual's right to say whatever they want to say about any candidate, but they can't do it, they can't do it anonymously. So my recommendation then is on line 12, 8505, maybe we just match is guilty, shall be subject to a civil penalty of no more than $5,000 per each separately produced message. So that's consistent with another chapter down the road.
8504, Senator?
Yeah. So on line 12, I'd say every person shall be subject to a civil penalty of not more than $5,000 per each separately produced message. And then you say, comma, who intentionally writes, prints, posts, or distributes or causes to be written, then everything else in that paragraph follows.
Thank you. On the amendment? No objections? So ordered.
Okay, thank you.
We're now in Chapter 9, Section 9101,
Chapter 9.
Section 9102, 9103, 9104,
Oh my goodness.
9105, 9106, 9107, Section 9108, Section 9109, Sections 9110. Okay, Senator Barnes, 9109. I believe the time needs to be changed.
Yes, Mr. Chair, if I may, I do know that on section 9109, the poll shall be opened at 8 a.m. I do know, if I'm not mistaken, was previous legislation where it was the opening of the polling places would be at 7 o'clock in the morning, and then the closing would be at 8 in the evening. So, if I'm not mistaken, right?
Senator, would you like to?
So I'll
propose
make
something?
that amendment that the polls shall be open, change 8 to 7, and that would be 7 o'clock a.m.
Okay.
That
on
means they have to
on
wake
that.
up. Yeah, right. And that's what contributed to the problem.
Yes, that's what we're talking about. It's 0. The current law says 7 a.m.
Okay, on the amendment, no objections?
The amendment is to change, based on the current law that we have, that the polls shall be opened at 7 o'clock a.m. and not 8. So we're changing 8 back to 7. Change at 8, change that to the word 7.
And that, I think the commission thinks that's fine, but perhaps if you give it just, consider it a little further, that, I think, in my view, in my opinion, contributed to part of the problems for the entire day, because in order for them to announce that the polls are open at 7 o'clock, that means they would have had to arrive at the polls no later than 5:30, 6 o'clock, and count every ballot and account for every pencil, every eraser, every box, every envelope, and deal with the absentee envelopes, because technically they should have cast those before the polls open. So between in the 2010 election, everybody had to be down at the election commission by 4 o'clock, if I'm not mistaken, John. Mr. Taitano? Yeah, it was at 4 o'clock, and people were running late. And it just seems a little unreasonable to demand that they are there at 7 and be bright and bushy-tailed with the ballots.
I know, but just based on the maybe Mr. Chair, you'll do one of my colleagues here who's familiar on why it was changed at
Yes,
7. Maybe
Senator, I
could
was
give-
just told that they didn't change, the current statute has it at 8 o'clock, but I know the discussion is that, and the practice has been opening at 7 a.m.
It wasn't codified. I have GCA as of May 24, 2011, and it's still showing 8 o'clock a.m. In this, it's section 9109, and the source is showing 24273-4. And I think I looked it up. But we're saying it was changed.
Senator Bond used to have the floor. And then
Yes,
Senator Catholics.
I'd still like to. I'd still like to. No, I'd still like to at least check on the books to see, because if I'm not mistaken, Senator Casper Bauer introduced the legislation to change the time, and I see that Commissioner Mesa was the one who brought it up. And if I'm not mistaken, that was on a standalone bill and not codified. I mean, wasn't in any. And if a bill is a standalone bill and it gets passed, doesn't it get codified? And maybe it's an error by the compiler of laws, but I do know that this was a highly debated issue even back then. And Senator Ruth, if I may just say that when this subject was being talked about, there was concern from the private sector about not being allowed the opportunity to vote, so that they say you either do it after work or before work, and some of the private workers after work couldn't come back in time, and they were being shut out. So I'm just saying that I do know that legislation is there, and if we have to take a 1-minute break just to cite the section of the law, I'm going to ask for that.
I think
Just to check.
I think there's that understanding. So all we need to do is just now change it because it's not in statute. So yes.
I'm noting that the commissioner is asking that, for the record, that she wants Section 901 to remain, to be, and of course it's our prerogative to change it, but she's got a justification on why she thinks that should be left at 8, and this is something I just want to see based on maybe Senator.
And Senator, also, at the time that you were discussing the business people who said that they wanted to vote ahead of time, this proposed measure requires employers and grants employees the right to go for 2 hours.
Yes.
And if they're saying that they want to vote before 8 o'clock, that's because they're not willing, perhaps, to give that employee 2 hours, and they really should. And anybody who does not follow and allow an employee to go vote, it is incumbent on that employee to tell the election commission, and they're subjected to a fine, or to the Labor Department who can set up fines.
Senator Ruth, I can understand your
Yeah.
justification on that, but I just want to share with you, as recent as last week, I was called by a couple of constituents in reference to this matter and the rights to that administrative leave process for the time allotted for 2 hours, and it was talked about. That's the reason why they had pushed for the 7 a.m., but it is still a concern where employers will not let their employees go, and that's why some of them, or quite a number of them, and this is in the private sector locally here that deals with over 1,000 employees, and they're still concerned about not being given that time to leave before or after.
And employees in this bill can go to the Department of Labor, and this allows or authorizes the Department of Labor to establish fines for those employers who do not allow their employees to go. But the going back to the 7, 8 o'clock, opening up at 7 o'clock is just not that, it's not early, but it's almost unreasonably early for those who have to prep to make sure that everybody's getting the right boxes on the right buses, and just the sheer logistics of getting the supplies out, and then when it arrives at the precinct, these people are expected to account for every little thing, to make sure that the ballots, and certainly the ballots are the most important, that they all correspond with the numbers that it says on the paper, and to deal with the absentee ballots, envelopes that accompany them when they get to the precinct. So to do all that and, be ready by 7 o'clock to take the first voter is cutting it close, and in my opinion was part of the problem that contributed to some of the rules and procedures that were not being followed. Not to mention the ones those precinct officials or precinct workers or precinct clerks that didn't show up on time.
Okay, thank you. Senator Barnes?
Thank you.
You still have that amendment?
Yeah, I guess I can understand and feel for Senator Ruth's concern regarding that. And I do know at the request of the constituents, knowing that that was online, I shared that sentiment that that was the law and that it was at 7 o'clock. So, and I know that there will probably be confusion again when this comes up, and I'm just feeling that, I mean, I just believe that the motion to go back to that 7 o'clock based on what was legislated would still be in order, and I was just hoping that this was going to be a technical change and not a motion to change. Because if I can just ask legal counsel, if I'm not mistaken, it's 7 a.m., right? Yeah. Oh, she hasn't found it yet. So if we could just, I guess, move on to the different sections and then have the opportunity to come back on that if it's in law. Okay?
All right.
Okay, thank you,
Please.
Senator. We'll come back to sections 9109. Any other discussion on 9109? We'll move on to 9110, 9111, 9112, 9113,
I'm so
9114, 9115, 9116, 9117, 9118, 9119, 9120, 9121, 9122. We recognize Senator Tom Atta for 9123.
Thank you, Mr. Chairman. I've passed around the amendment for section 9123, which is on, excuse me, on page 77, starting at line 12, rules for determining residency. And down on page, down on line 18, sorry. It speaks about the residency of a person is that place where, oh my gosh, wait a minute, I think my numbers are, wait, 9123G. Oh, I'm sorry, 9123G starts on page 70, on page 78 is where I want to make a change. Line 18 talks about no person who is registered to vote in another jurisdiction may vote on Guam until that person's name is removed from such registration. And of course, it doesn't, it's kind of until it's removed from such registration, and the commission shall provide affidavit. So the amendment I want to make is so that it reads, no person who is registered to vote in another jurisdiction may vote on Guam until the commission has transmitted an affidavit to said jurisdiction requesting that person's name to be removed from such registration or the election rolls. So really it's hard to, you know, I come in today to register and I'm registered in San Francisco. Well, we can send that affidavit to them, but we'll never know when they've taken it off. But I think just the fact that the commission has taken that initiative to transmit it, and hopefully, you know, they will get around to it, then I think that would satisfy what it is that we want to do. So that's the amendment that I'm making to section 9123.
Vice Speaker, you recognize, and then Senator Blas.
I support the intent of this amendment. I'm just trying to figure out the best way to address this, because it would seem to me, under the current practice throughout the country, since residency on Guam really is only 30 days, right? So I can move to Guam on sometime in the middle of, beginning of October, sign to vote on Guam, and at the same time, send an absentee ballot request to my home in San Francisco, receive that ballot from San Francisco, vote in the presidential election for 2012, plus vote for the senatorial election here on Guam. And how do we prevent that? I understand what the proponent of this amendment is trying to get to, and I support the intent to make sure, because a challenge in a previous section 9118 has that he is not voting in another jurisdiction. G 20 on page section 918G, that he or she voted in another jurisdiction. That should be basis for a challenge. But it just seems to me that the way that you have absentee ballots in the States, you could ask for an absentee ballot, vote in Las Vegas and Guam at the same time. And I support the intent, so I'm trying to figure out how to best address that to make sure. Could that be, is that one of the offenses of the earlier? Voting in two jurisdictions?
Vice Speaker, I think in the past, the Commission has been faced with that challenge on the example you just gave. And during the discussion on that particular topic, since the voter has to sign an affidavit under penalties of perjury, then that is the only safeguard we have, unless somebody else raises it up, in fact, says that that person voted someplace else, then they can be charged under the penalty section.
Under the perjury section?
Right.
Okay.
Thank you, Vice Speaker. Senator Blas?
Thank you, Mr. Chair. And I think along the same lines and the concerns brought up by Senator Cruz is, I guess when we were drafting this, my question is, how do we enforce it? Quite honestly, an individual can walk in, and if he doesn't say anything about him being registered to vote anywhere else, how do we enforce this?
On the person's word, Senator, basically when they come in, the question is asked, are you voting elsewhere? If they say yes, then there's an affidavit canceling that registration, which the Commission sends back. The voter then executes the affidavit under penalties of perjury. Now, if in fact they go out of their way to violate the law, we won't know that unless somebody challenges it.
Okay, well, then I guess along those lines, then I support the amendment that is proffered by Senator Ada. I see I see the concern here. My question, though, is the enforcement process of this thing, recognizing it's basically on a person's word. But along those lines, if there is that process, if the individual does say that they in fact are registered to vote in another jurisdiction, maybe there is that responsibility of the Commission then to provide that affidavit. I'm not adverse to also then maybe the language to help to cut down on the costs is then provide the individual, the responsibility themselves of saying, okay, now that you're registered, here's the form, this has to be mailed. I'm not quite sure. I'm looking at the practicality of the whole thing. Then also I'm looking at the money that's going to cost you to do this. Albeit it may be small, but I'm looking at the administrative time, the logistical time and whatnot to be able to accomplish this. Maria, you have a...
Senator, we actually do it now.
Okay, that's good.
Yeah, we
Great.
do it now.
Okay, so then there's no problem with the amendment being proffered by Senator Ada? Okay. Thank you, Mr. Chair.
You know, Senator Blas, that's a valid question you asked, the enforcement. The truth of the matter is that most voters are going out there, and when they go to register, they want to vote in their jurisdiction where they're living. If someone wants to do something that is outside of the lines, like voting to jurisdictions, it'll be hard for any election commission to, so the question is do we not take somebody's word? Because that's been the process, and you know, in the last election there were some cases where people voted both in Saipan and here. Now maybe they live here and there and they felt like this is what they could do. In accordance with federal law, that's illegal because they voted for 2 congressional delegates.
You bring up a good point here, because how does this work in the cases of dual citizenship?
You got to choose one or the other. And that's by honor system. So.
No, dual citizenship.
Oh, dual citizenship, like you're in 2 countries?
Yeah.
I don't know how you would handle that.
Recognized Vice Speaker.
I think the difference there is what Commissioner Carrillo mentioned, where they're voting for 2 congressional delegates. But in the dual citizenship, I think the dual citizenship that's allowed for the Palauans and for the Filipinos both allows them to vote here and there, as long as they're not voting for the same, it's not the same type of office. I mean, yeah, but their legislature in the other jurisdiction, but that's a foreign law and it's recognized. I think the ones that control is the congressional one, because, and that brings up another question, but I'll ask that question later about the congressional election.
Then along those lines, maybe there's something that's missing here, because if you read this just in its face value here, it says in another jurisdiction. That can be liberally and can be interpreted to be outside the bounds of the United States as well. That's why I'm concerned here as well.
I feel like your concerns are valid, but the truth is, people who break the law more oftentimes than not get away with it.
Yeah.
But
I don't want, at the same time when we're trying to do this, I don't want individuals who have that opportunity through dual citizenship, you know, because the way it reads here, yeah. I mean, we don't even address dual citizenship in this thing, and yet we say that you can't vote in one jurisdiction or another. We're not delineating as to whether or not this jurisdiction has got anything to do within the United States, within the bounds of the territory of Guam or the United States for that matter. And in the cases of those individuals who have dual citizenship, Philippines and Guam, or Palau and Guam, or FSM and Guam.
Thank you, Senator. On the Tom Ada amendment, want to close, Senator?
Well, I think the preceding speaker certainly raises a valid point, and I think that can be very simply addressed by just putting in there on the first line, no person who is registered to vote in another U.S. jurisdiction may vote on Guam until the Commission has transmitted an affidavit to said U.S. jurisdiction requesting that person's name to be removed.
I don't have a problem with that one.
I think that amendment to that amendment. And, yeah, and then I guess just one technical, I would say probably a technical matter. On the third line there it says removed from such registration, and maybe to be consistent with the term that's being used, I guess we want to say removed from such election rolls. That's how they describe it down in the next line, as the election roll.
Okay. On the amendment, is there any objections? No objections. Motion carries. Now on 9124, Senator, you have another amendment?
Yes, Mr. Chairman, on section 9124, starting on page 79, line 14 through 16. And again, it's a similar thing. I'm proposing that it should read, no person who is registered to vote in another U.S. jurisdiction may vote in Guam until his or her name has been requested by the Commission to be removed from that jurisdiction's election rolls. So it's a similar, again, similar idea. The individual fills out an affidavit. Election Commission then just mails it off.
Thank you. On the amendment? No objections. Motion carries. 91. We're now on 9125.
On 9125, I didn't pass this one around because I'm just not quite sure. But I have some concerns about. Right now, it reads that that individual is going to be going to be entitled to 2 consecutive hours off, but that he will not be liable to any penalty, nor will any deductions be made. So in essence, we're mandating that in this case, the private sector will give 2 hours of paid leave for that voter to go and vote. And I have a problem with that, because if your normal work time is between 8 and 5, then you still have from 5 to 8 o'clock, and then now if it's going to open at 7, you've got that 1 hour. So I think maybe what we want to say is that he's got to be given that 2 hours, whether it is lunchtime or after 5 o'clock. And so I made an amendment that really proposes to remove the words on line, this is on page 81, on line 5 there, at the end where it reads, the voter shall not be liable to any penalty, nor shall any deduction be made on account of such absence from his or her usual salary or wages, nor shall the voter be suspended or discharged from his or her service or employment. And I think we should delete that sentence and simply say that he's entitled to 2 hours, and if he's not given that 2 hours, then a violation of this provision shall be reported to the Guam Department of Labor for enforcement. Now, I'm not sure, is there a Guam statute that says that a private, that an employer has to give 2 hours off? I don't know. If there is, if this is the current statute? Well, if that's a current statute, I think it.
And I think it was Senator Parkinson. I think it was Senator Parkinson who insisted that the same sentence that you're now trying to delete be included, if I'm not mistaken, if I recall correctly.
And so my amendment will be to delete that sentence.
Speaker, on the amendment, Speaker Ben?
We're seeing the debate across the country of trying to maximize opportunity in which the citizen does not suffer things aren't put in his way to prevent him, and things are put in place to encourage him to go out and vote. The more democracy we have in effect, the more participation, the better the decision and the outcome, I think, with regards to our elections. And we find that maybe this is one of the reasons why we have an 87, 88, 92% turnouts in elections, is because we don't place any kind of impediment in which the voter may suffer any kind of hindrance to being able to go out and participate in the democratic process. And I don't think it's been an onerous burden on the companies. I think over the years they've accepted it, they're practicing it, they're encouraging it, and so I think to retreat from that, I certainly would not support something like that. We see the same debates going in terms of trying to make it easier for people to vote, and I think if we do this, then we're going to be on the other side of the trend here of trying then, removing something that has made it easier for our voters to vote, to putting something then that would inhibit their ability to go out and vote, different from what is practiced today and over the many years that we've had. So I think I know that I am objecting to the motion to delete that provision.
Thank you, Speaker Ben. Is there any discussion? Any other discussion on that? If not, I'm going to ask for a 30-second, before you close, Senator, I'm just going to ask for a quick recess. No, we're going back on. Committee of the Whole is now back in order. We were on the amendment of Senator Ada, section 9125. We're going to put that to the side and come back to that. We're now on section 9126. (9127). Vice Speaker, you recognize?
Thank you very much, Mr. Chairman. This is current statute, is it not? 9127. It is current statute. And I'm just trying to figure out how was it that in the last election there was differing interpretations of this? I know some of the commissioners are trying to fall behind their glasses, but, is there a way that we can make this clearer so we don't have this problem? It's not something that I'm going to have a problem with because I'm not going to hyphenate my name, but there are, I know that Reverend Tax is currently having a problem right now with some of the women who are trying to hyphenate their names and carry, and so I'm just saying, I really am concerned about this section and the way that it's being interpreted, or do you guys have a clear SOP to make sure that we don't have a problem with this section again of women who get married the month before the election and show up and their last name's Cruz, as opposed to being Fruncus, which it was the month before?
Thank you, Mr. Vice Speaker. Again, these were one of the SOPs that were not followed to the T. There is an SOP. There was some difference in interpretation or instructions at some of the precincts, but this should not be a problem in the next election or future elections.
Thank you, Vice Speaker. Any other discussion? 9127. Moving on to 9128. 9129. 9130. 9131. 9132. Vice Speaker, you recognize?
Is 9136 provide for, all right, then it's the assistance, because I wanted to make sure that some people get assistance. Thank you.
Okay, 9133, 9134, 9135, 9136, 9137, 9138, 9139, 9140, 9141, 9142, Section 9143, Section 9144, Section 9145, 9146, 9147, okay. So 9147 up to 9153 is being deleted. Any discussion?
Yeah, move to different chapters, yes.
So yes, it was moved to Chapter 8. Yes. Senator Blas?
I understand that we're working with two different documents, one the digest and the other one. I'm actually working with I guess the bill is presented on the floor. But I think for the purposes of clarity and recognizing that we probably moved it, I think that it's probably best, and maybe it's a technical amendment, to indicate that these sections that previously existed in this section is now found in other sections. That way it doesn't show that it's basic, it's not a deletion, it's just moving it over to the other places.
Okay, so what's the amendment? I'm sorry, I didn't hear.
Is recognizing that you said 9147 to 9153 were not necessarily deleted, but they were moved to other sections of within the chapter, right?
Mm-hmm.
So that for the purposes of clarity and so that we don't show that we just outright deleted it, we actually moved these sections to other sections.
Okay, Vice Speaker, do you want to?
Maybe the two legal counsel might be able to assist us in affecting what the proponent is suggesting. Should it not be utilizing what they use at the compiler, renumbered, where they say 9147 and whatever the subsequent numbers renumbered to in Chapter 8 to a different number, so that as the senator from Barrigada Heights put it, it's not deleted but it's just renumbered.
Yes, and so if we could have the legal counsel. It won't show. Okay, that's right.
Actually, we can tell you where they were moved to and renumbered, but then when the final version of the bill was developed, the entire thing had to be renumbered again. So even if I tell you that subsection 9147 in the existing statute for the proposal was moved and renumbered to subsection 8309. In this bill, it's a new number.
I understand,
so that's 2 or 3 times removed.
And I appreciate and I recognize it's just that I think for the purposes of clarity here, and I'm going to speak for myself here, is it's shocking to say, okay, well, because when you said 9147 and nothing here, then I hear that there was 9147 to 9153 was moved. What was it moved for? Why was it moved? I mean, there's all these questions that I have that could have been easily answered in a bill that we're supposed to be deliberating, and recognizing that it has been moved. It hasn't been deleted. If somebody was to go and look at the law as it exists today and then see this proposal without knowing this conversation we're having right now, they're just going to assume that it got deleted, when in fact it didn't get deleted. We just moved it. So I think for the purpose of clarity on this point, not just for me, but for other people who may want to look at this thing, and be comforted in recognizing that it wasn't deleted, it was in fact moved to probably better places within the chapter, that be recognized here. It's a little bit more work, but I think that we, it's necessary to be able to show that. I don't think it's going to take away from the intent of the legislation itself. It's just for the purposes of clarity we're showing.
Okay, thank you, Senator Blas. Speaker Wanpet?
On that same subject, I think that maybe what would help, because in the past I know that when things end up in court or people want to find out what has happened, is that there's some tracking. So that means they're going to go back to the committee report and they're going to look at what the legislation is and where the markups are at. And I think that maybe in the draft version, not the engrossed version, that I think if you indicated that, then that way it'll be easy then to go back and forth. Because I know it can't and it won't show up in the engrossed version, but it can on the edited or the marked up bill. Because I had that same concerns, and that's why when we were first working with the final copy, it was confusing when we didn't know where exactly all the amendments were being made and how the numbers have changed. And now, of course, you've asked us to go back to the other draft copies of it, and now we're able to see that. So you're right, it's going to be a little more work, I think, on the committee's part, more so really than it is on the legal side, because they're going to go on the basis of how it's engrossed and making sure that they're numbered, correctly in the code.
Okay, thank you, Speaker. And if we could, I've listed this down, and so we can come back to it when we go back to the others, so we can figure out how we can address that. Are you okay with that, Senator Blas? Thank you. Okay, we're now on Chapter 10, absent voting. Section 10101, Section 10102, Section 10, Speaker Ben.
When we say just on attendance at an institution of learning, so it's just, we're not limiting it to any kind of structured. Could you, if you enrolled in, Strippers Academy, off island, are you still eligible to vote? Yes, it is. I just want to. So there's no. Our intent is not to provide any kind of qualification for this institution of learning.
As long as they're attending
Well-
school.
I suppose you can.
Okay. Was there any recommendation or discussion? To
No.
that? No. All right. That's my question.
Thank you. Section 10, I'm sorry. Section 10103, 10104, 10105, 10106, 10107, 10108, Section 10109. Speaker Ben, you recognize? Okay. Section 10110. Section 10111. Section 10112. 10113. 10114. Section 10115. Section 10116. Section 10117. 10118. 10119. 10120. 10121. 10122. 10123. Section 10124. We're now in Chapter 11. Vote tabulation and declaration of results. We're in Section 11101. Section 11102. 11103. 11104. 11105. 11106. 11107. 11108. 11109. 11110. 11111. 11112. Section 11113. Section 11113. Speaker Van.
I'm sorry. I was leafing through fast and something caught my eye and then I needed to go back to it. 11106, rejected ballots. The change from a majority to all members of the precinct shall endorse upon all ballots rejected and shall write and attest to the cause of the rejection. Are they making, are then the precinct board making the decision to reject these ballots? We don't have what we call, I don't know that we call them provisional ballots where you kind of put them onto the side, Joe. Is that what?
No, these are the actual absentee.
The absentee. And so we're allowing the precinct board to reject those ballots? That they get it to decide to reject the ballot and then they all write on it? Or if the ballot is somehow rejected, then they have to sign off on it? I mean, I'm not sure of that process.
Just give me a second to go back.
11106. See, the title says rejected ballots, and then it says all the members. It's being changed from a majority to now all members of the precinct board shall endorse upon all ballots rejected and shall write and attest to the cause of the rejection. So, I mean, this is the ballot itself. It's not their ability to vote, you know, because you can, at the precinct level, say, oh, you don't qualify to vote, your name's not on the roll, and so forth. But this is the ballot itself. I would think that only the commission members can reject the ballot. Now we're saying the precinct board members can reject these absentee ballots for whatever reason. And I'm a little unsure of why that would be the case.
I'm just trying to reconcile this,
Sure.
but this is old language.
I know, I understand.
I know that in the past that if, for example, if a absentee ballot was challenged.
Right. Then it goes to a provisional,
No.
a resolution ballot.
No.
No?
Then the precinct board would hear that challenge, and if they ruled in favor of the challenger or vice versa, either one could appeal to the board, and then if they still objected with the board, there's a judge that's a standby on that day. But on this, I mean, you raise a good point on this one.
Yeah. So I'm on,
In fact, this was enacted back in the 11th Guam Legislature.
yeah.
What?
So again, I'm just a little concerned because I've also seen us go away from these resolution ballots, and I really think that we need to, you know, go back to that process. That every ballot that's challenged, every ballot that's rejected, every ballot that's kicked out by the machine, really should go into this resolution ballot status pile, and then each one is handled by the election commission, and you decide whether
we still do that.
you still do the resolution.
Yes.
Okay.
We have a resolution committee.
Okay. All right.
Yeah.
But this kind of the reason why I kind of noticed it because we went from majority to now unanimous, and then that caused me to read a little closer what exactly is being authorized by this section, and I'm not sure that they have the authority to reject those ballots because it's already been cast. You know what I mean? If it was prior to casting, you could prevent somebody and then be challenged, and then they can make a decision to allow that person to vote. But I would think that every ballot that is challenged or rejected at the thing, I want to make sure that that's not the end of it, that ballot goes to the commission, and the commission makes the final decision.
Yeah, that's still
Are you sure?
Yeah, I'm having a hard time reconciling this. I know we didn't touch this, but
I know. Except for now you're changing all members to before just a majority.
but before, the current language is saying majority. I'm saying it's all.
That's what I mean.
Thank you, Speaker. Senator Blas, and then Speaker Juan Pen.
Thank you, Mr. Chair. Mr. Chair, again on the 11106, I think there's a little bit here with regards to some grammatical, because then if I'm to read this, all members of the precinct board shall endorse upon all ballots rejected and shall write and attest to the cause of the rejection. My question is, and shall write. Who's going to, all members shall write? Because the way it reads right now is all members shall write.
Yeah. Perhaps it is just a grammar thing, but
Who specifically then should we say that this is that person responsible
all the members, it says here, all the members shall endorse. That means actually writing on the envelope, you know, or and shall write and attest to the cost. These rejected ballots are supposed to be placed in a secured box and in an envelope, and the envelope should indicate why it was rejected, and all 5 of them would be signing it.
Okay. Well, the signing is shall write and attest. I'm you know, what I'm saying is this appears by the language to be very onerous.
And see what we had, perhaps.
I just don't want you, Ms. Senator Ruth, to be able to be, you know. I mean,
Yeah, where is the original? The original says a majority of the precinct board shall endorse upon all ballots rejected for illegality the cause of rejection and sign the endorsement. That's
Okay.
all the existing statute. And what this says is all members of the precinct board shall endorse upon all ballots rejected.
And
That
shall
means-
write and attest.
And shall write and attest to the cause of the rejection.
That's
I
what I'm
guess
saying.
the attest is that they all agree for the cause of the rejection.
Yeah. I see what you're trying to say. I see what you're trying to get accomplished, but I don't think this language says that. This language basically says all of you have got to be responsible for giving your own opinions to why it was rejected.
We can change it.
Yeah. I needed to know what the intent was, and really,
It's just for better accountability to make sure that all 5 of them and not just 2 or 3 know why it was rejected. That they should all know what the other is doing. I think because they could reject it for different reasons, that's correct.
okay, my question then is, who is going to be responsible for writing the reason for the rejection? I can
Oh.
understand each board member attesting to it.
I suppose the leader would. I mean,
Okay,
because
so,
there's only 5
and-
of them, and there's only 1 leader.
Yeah.
So the leader, we assume, or I would assume that the leader is the one heading it because he is in charge. So he would be the one, and the other 4 would be agreeing with him and signing to the rejection.
So then you want,
So
and the-
that the leader is not acting on his own or just.
so then, and the precinct leader, so and the precinct leader shall write?
It's, yes, because it has to.
Yeah, that's
it,
what
it
I'm
has
getting,
to
is
give-
I want to get past this,
Yeah.
because the way it reads is all of you have got to write.
Yeah, the precinct leader shall write. It should, and attested by the other members.
Okay.
So that he doesn't have exclusivity in deciding the reasons for the rejection.
So the precinct leader shall write and members attest to the cause of the rejection?
Yes.
And the precinct
If-
board,
If
okay?
you want clarity, that would be the
Yeah,
way
I think it's better,
to
because
clean
then
it
this,
up.
the way it's written here is all of you got to write.
Okay, that's fine.
And I just want Mr. Mesa and Mr. Tite to know.
So it would be.
They don't like writing.
Endorse upon all ballots rejected, and the precinct leader shall write, and the
And-
member shall attest
Right.
to the cause of the rejection.
Okay.
And if now that it is that clear, perhaps you might consider not requiring all 5, perhaps a majority.
Well, then it goes
It
back
should
to the
stay-
question, I'm sure, by the good
Yeah, maybe
gentleman
it
from
should stay
Vermont.
at the majority.
So Senator Blas, you want to, you want to offer an amendment?
Sure.
On
As
what was just
proposed
stated?
by Senator Ruth there.
Okay.
Commission members.
Okay, so the amendment is going to read, all members of the precinct board shall endorse upon all ballots rejected, and the one we're going to add is the precinct
Leader.
shall write,
And
and all members shall, that's what we're adding,
Right.
attest to the cause of the rejection.
Yes.
Okay, on the amendment,
All members of the precinct board.
shall attest to the
Right.
cause of the rejection.
Yeah.
Okay. On the amendment, no objections, motion carries. Speaker Wonpet?
My question is, because I know it was originally the majority, and now we're saying all members. And what if then by chance that there is a member who disagrees? Then what? Is there any provision here to address that? So, or is the one member who refuses should sign off by saying that I
Disagree,
don't agree,
yes.
right? So there's a provision for that, only because it's
Well,
written this way that all members must.
Because he made it so specific as to say who, and shall report and who shall attest to. Perhaps it should go back to now the majority, so that if there is one or there are two members who disagree, then the majority rules. So Senator Pangalinan's point about the majority versus now why should there be all five, it was just the commission's attempt to gain more accountability, or to demand more accountability on the part of the precinct officials, that they all know what the other is doing. But if you want to specify that the leader has to be the one to write the explanation as to why the rejection came about, there has to, and be attested by at least two others, then it can go back to the majority, a majority of the precinct board.
Yes, I agree. Primarily, unless you're going to say that those who, or like all members can sign off, but
Right,
meaning though that, let's say the majority, three of them are going to sign endorsing that it is to be rejected, or four, but one does not, and the one who signed saying, of course, that he has objected to, what the majority has agreed to.
Okay, so do you want to?
I think the majority, going back to the majority,
because,
would be better.
sometimes people can be, intimidated into, forced, of course, into just all agreeing to say, okay, we're going to accept this, and somebody might say, no, I don't think so, and prefer that it goes up then to, the committee that's going to resolve this, issue, not necessarily them at their level, but at least their concern will be addressed, with a different group.
So, Speaker, do you want to move it back to a majority?
Yes, but then I think I like to go back to a majority.
Okay.
But then there should be a provision here, language to say that then at least the one who's objecting would state the reason as to why he's objecting and sign off on that. So it's everybody really signing, which is not a bad thing at all, but everybody has an opportunity to state whether he or she, is endorsing this rejection or is, may not. So I don't know how we can write that. I can ask legal counsel to see then what additional language will be needed for that. So we can maybe skip this now, just quickly run up there and see if language can be written.
Okay, thank you, Speaker Wampat. So we'll put this aside until we get an amendment ready. Okay, we're now on 11. I'm sorry, Speaker Ben.
Having discussed 11106 a little bit more, and then reading 11107 a little bit closer, then
Did it explain it?
no, it doesn't. It actually then there's another category. Now you're adding another category of ballots, a rejected defective ballot. But the ballot in 11106 is not necessarily defective. So we should return. And where did the defective come in now? You know what I mean? Would it be just, I guess the defective ballot is what? Because you have now you have rejected ballots, and now you're adding this rejected defective ballot, and I don't know what that is.
Actually, I think we don't even need this section. I think because it's covered, the handling of ballots, any type of, is covered throughout in other sections. This has been since the 11th Guam Legislature, and I really, I'm not sure how we handle stuff like this, because there isn't. There's different categories already.
Yeah. So, not being that clear, I'm not going to make the motion to reject it until I understand it a little bit more. Yeah. But that defective ballot should never get to the precinct. That defective ballot should never get to the precinct.
So Speaker, we'll take a brief recess. Committee of the Whole is now back in order. Speaker One Pat, we're back in 11106.
Thank you very much, Mr. Chairman. Mr. Chairman, after speaking with legal counsel to see how then we will be able to incorporate a member or more who refuses to sign off and attest to a certain ballots being rejected, that the language as recommended, of course, by the commission actually would suffice with a minor change. So that means, first of all, we need to, notwithstanding, of course, the actions of the legislature, this body that have accepted the amendment to include that it will be the precinct leader and all members to attest and sign off, that instead is that to delete that and just add the words then, and that each member shall write, then what their reasons are for attesting to and the reason for the rejection or no rejection. Yeah.
If I may, Mr. Chairman, and on that note, you went through the sections and nobody said anything, but there is a section specifically for causes for rejecting ballots and defective ballots. Yeah, 10, it's subsection 10119, I believe.
1019.
The title is Causes for Rejecting Ballots. 10119, okay.
Page 103 is
Yes, but nobody said anything then, so. And we also,
page 103.
On the digest that you're...
On the digest.
10119.
and defective ballots is 11112. Under, this is, so one is under Chapter 10, the other one is Chapter 11. Defective ballots is Chapter 11, I think.
Then that makes it even confusing to go back to that other argument, of course, by my colleague here, is that these could not have been placed one right after the other if you're going to talk about rejected ballots, defective ballots.
Well, I
and
think,
so on.
Senator, Madam Speaker, at that point, the committee or the subcommittee did not move it to incorporate those because they do appear under different sections, under different titles, but nevertheless, we glean from the statute and then it goes into the election manual. So the election manual that dictates to the precinct officials what to do therein is where they would see it, but for purposes of having it in the books, no, the subcommittee did not move those around. But be assured that during the seminars and in the election manual, these are all defined, and they're all together.
So then, so you're saying then with 11106 that the individuals, the members then who we're trying to allow them to disagree will be able to note their disagreement, that is in another section entirely.
It appears that way, yeah. defective ballots is 11112.
That's later on. Huh?
It's chapter 11. Yeah.
So, Speaker.
And because you have these rejected ballots, defective ballots in past elections, and perhaps that also, I don't know, I'm just basing it on what I've read, what I saw, but perhaps that contributed partly to whatever confusion or mistakes, human errors that were made that day, perhaps was because these people did not have, all these containers to put all these different sets of documents in. And so we plan to have, if there are 54 precincts, how many precincts? 58 precincts, we require 58 secure containers, whether they're the hard plastic containers. They don't have to be humongous, but nevertheless, they need to be sturdy and with a cover, and they would be marked rejected ballots. And then we'd have to have another 58 for defective ballots, and then we have, envelopes for the absentee ballots, and just the envelopes themselves, because those are very important, because they attached or on the face of those envelopes are the affidavits that allow them to cast ballots in the first place. So you're talking of just those defective and rejected, you're talking of more than 100 additional containers that we need to procure in order to get everything set and processed. Because in past elections, they've just all been combined with all the other documents in one main container. So just to kind of allay any fear that or confusion if they're looking for something, or later on the commission is looking for a certain document, that it might be easier to track.
So in 11:27, you have to add some category. Either just say defective ballots, or say, and then add rejected ballots. Because they are two different ballots. The rejected ballot and the defective ballot are two different.
Yes.
So here you have, because you're saying rejected defective ballot, that's a single category, and that's not true. You mean rejected ballot and defective ballot. So there's another category that they must be returned.
Yes. Yes. Joe, where did he go? Oh, can you please type in whether you agree or disagree?
Yeah, you could do that. Actually, I don't even think you need this section, though.
I think the commissioner stated that this section was not needed because throughout the title, there's provisions there that for spoiled, for defective, for rejected. So that's their recommendation, that if this body wishes to both, right? So is there a motion based on the commissioner's suggestion?
I think we should recess and come back fresh tomorrow. No, seriously, you got a 6 o'clock public hearing.
Okay. All right. Okay, so we'll recess until 9 a.m. tomorrow morning. Thank you.